Hi, everyone. We have Travis on, and he was a prior consular officer, diplomat. What are some things that the public absolutely needs to know and that they just get it wrong?
I mean, there's a million, but I think, the first thing I often say to practitioners, to immigration lawyers, is the visa officer is not your enemy. It's a difficult perspective to maintain. But if you think about it, I and virtually all of my colleagues joined the State Department to make a difference. We joined to promote the United States abroad. And one of the first things you're taught in your consular training, it's what we call congen, is that you may actually be the first American citizen, the first US citizen who this visa applicant has ever talked to. And we have to deliver bad news quite often. A denial is not an easy decision to express to an applicant, but it is impressed upon consular officers to express to present that bad news in a diplomatic way. And I think that, it's something that we all kept in mind. And I think beyond that, we all did and they still do take this job very seriously. A visa officer's job is essentially to be skeptical, to poke holes in an applicant's story or a petition that's been approved. And the default is really a denial, unless the applicant can establish that they're qualified for whatever visa they're seeking. But I think by treating the visa officer as a partner and not as an adversary, and that goes for us as lawyers and for the applicants themselves, you're going to be far more successful. Put yourselves in the shoes of a busy, stressed out, maybe exhausted visa officer. I used to interview well over 120 applicants every single day, and
Wow.
making those decisions every 1 to 2 minutes. And you know that each decision is potentially life altering. And so if you keep your perspective as I need or my client needs to present their qualifications to somebody who is trying to make the right decision. They're trying to do the right thing, but they don't have a lot of time. They're probably tired. They've been lied to several times already that one day, if not that week, that month, that year. Then think about how you can work as a partner. And once you establish that partnership, that rapport, and you can establish as an applicant or as a practitioner that the truth is paramount, everything's being presented with as much context as it can possibly be presented with, you're already going to be 10 steps further ahead.
Is it true that the cases are pretty much 90% predetermined before they even get up to the window because they already submit the S-160, you guys already like reviewed everything and I mean, did you guys already make up your mind before they even show up to the interview?
Absolutely not. First of all, the short answer is absolutely not. Let's talk about non-immigrant situations and immigrant visa interviews kind of separately here. So for most non-immigrant visa applications, really everything other than maybe an E2, where a packet of information is submitted directly to an embassy or consulate, the visa officer has not much to go on. There may be an approved petition from USCIS, but generally speaking, the system that the officer uses to look at those documents is pretty clunky. Things that are in color when they're scanned by USCIS may show up as just black squares to a visa officer, and beyond all of that, there's just no time. I mentioned earlier I was interviewing 120, sometimes 150 people every day. I don't have time to look through an approved H-1B petition or every response in a student applicant's DS-160 application. The way it
Mm.
does work is the applicant gets to the window. They have their, DS-160 confirmation sheet with a little barcode on it. The officer scans that, or maybe the applicant's been put into a small batch of people, so their information appears when they walk up to the window. And that's literally the first time the officer sees or knows anything about the applicant. They're going to see, if this person has been approved or denied previously. They'll see notes from previous visa interviews. They'll see if there may be a pending immigrant visa petition out there. They'll see if this individual has a criminal record from the United States or many foreign countries. And that's about it. And
Mm.
so you really can't make a decision until you start asking questions. And that's the whole design of this wacky system to require people to come in person for a visa interview is precisely so a specially trained human being can evaluate what is said verbally and then make a decision. Now,
Mhm.
the immigrant visa context is a little different, right? Because by the time an applicant is at a visa interview, they've prepared and submitted lots of documentation, police certificates, medical examination reports, birth certificates, job letters, all sorts of stuff. But even then, the process before the interview is more like a checklist. And often it's done by local staff members just to make sure everything is ready to go. Or, hey, there's a key birth certificate missing. Let's note this for the visa officer. But the real work is still going to be done at the visa interview. So it's really I understand the myth, but it is a complete falsehood that officers have already decided your fate before the interview begins.
All right, here's another question then. Is there a quota? Number of visas that every consulate can issue because you guys have to order it from Washington.
There are no minimum or maximum limits once an applicant gets to the interview stage. For a lot of these visas, you mentioned H-1Bs, a lot of these immigrant visas, at the petitioning stage, that's when applicants are subject to like the H-1B lottery, which is in the process of changing, or EB-1 quotas, et cetera. By the time somebody gets to the visa interview stage, there is literally nothing, kind of macro level that factors into an officer's decision whether to approve it or deny it. I like to think of it as it is the applicant's visa to establish qualifications for or not. There's no kind of third factor outside the interview that will weigh on that opinion. There's one kind of caveat, one kind of
Okay.
exception to that, and that's more at the visa management level.
Mm.
So there are ways for managers to sort of monitor how individual visa officers are doing. Look at kind of their rates of denial, how many interviews they're doing a day. Of course, managers are expected to kind of shadow officers and make sure that they're making right decisions, they're treating people with respect, etc. If somebody is falling way outside of everybody else, and I've seen this happen before, one officer is just denying everybody. Well, that might warrant, and it should warrant a discussion from a manager to say, well, let's talk about how you're reaching these decisions. Why are you concluding that these people are not qualified? But other than that, there's no sort of firm maximum or minimum number.
That's fair. That's good. Good to know. And what should you do if you get a really outrageous result, like a denial?
I think the first question I usually think about is, was this clearly a legal issue? Maybe LegalNet is a good option to try. Maybe we can get another interview or have another remedy. But in many instances, it's probably a question of law. 214B, I mean, a question of fact.
Mhm.
214B is basically a factual determination that essentially you just haven't convinced me that you deserve the visa. It's
Right.
usually couched in this idea of having ties to home or not. But what it really means for a visa officer is at this slice in time during your visa interview, you just didn't convince me that you were qualified. And so all you can do is pick your bags up, go home and fight another day.
Mhm.
And so I think that's usually the sound strategy. It's let's take a look at what happened last time. What were the questions that the officer asked? How did you answer them? And from
Mhm.
there, we can usually say, you know what? You didn't go into any detail about this issue, or you forgot to volunteer this crucial detail that really supported your case. Let's try again and let's try to put the right details together and make sure you're prepared to, again, kind of draw the roadmap for your officer to conclude that you're qualified.
I think from this conversation, it's so clear that you need to know who's on the other side of the window. And because it is a conversation, and as great of a talker somebody might be, many of these people are executives themselves, right? People who have invested in companies, they're CEOs, they've hired plenty of people. They're like, I could do an interview. I've interviewed people. However, maybe they're accustomed to their own country, their own culture, and they're not quite familiar with the other person on the other side. And so they don't know how to say certain things, and that gets them into trouble. Never mind the language barrier. What is the demographic of the personnel, of the type of individuals who would be applying to this foreign service job, who would be want to be a diplomat?
It is as broad as you could possibly imagine. I will say, though, that most visa officers are not lawyers. And that is something that I think is interesting for us as practitioners and as applicants. Don't assume that you're talking to a legal expert. You know, when you're drafting a letter of support, when you're trying to explain why you qualify for an O1 or an EB2, your officer is not necessarily sitting there with a law book, you know, ticking off boxes on a clipboard to say, do you qualify? They're looking at you like a regular person, a non-lawyer would, you know, more holistically. Are you extraordinary? Do you have kind of a wow factor? Do I really feel confident that you're at the top of your industry? And I think if you can speak plain English more than legalese, you're going to get a lot further.